Here are 5 things you need to know about the fines that you may face if you're convicted of driving with a suspended license. This video is part 4 of an important topic, which is what's the penalty for driving with a suspended license. If you haven't seen parts 1, 2, and 3, I've included links in the description to this video. So let's get started. So first, what are the fines portion of the penalty? With a conviction on driving with a suspended license charge, you'll be facing multiple penalties, and I've covered those penalties in other videos. You should check them out. Regarding fines, you'll be facing fines that start at a minimum of $1,000 and they go up to $5,000. And these are the fines for each conviction. So let's say you're convicted of 2 driving with a suspended license charge, and you'll be facing fines of $1,000 to $5,000 for each conviction. In other words, you're going to be facing fines of $2,000 to $10,000. Second, you'll pay an additional 25% surcharge. Here's what that means and why. After the penalty has been laid down, the court will add a 25% victim surcharge. This victim surcharge is not optional. It's the law and is imposed under the Provincial Offences Act. The purpose of the victim surcharge is to help fund victims of crime. So on a $1,000 fine, the total fine will be $1,000 plus a 25% victim surcharge for a total of $1,250. And if you're assessed a fine of $5,000, then the total fine will be $5,000 plus 25% victim surcharge for a total of $6,250. 3, why are the fines a range and not fixed? Now you'll notice that the fines are a range, $1,000 to $5,000. They're not fixed. And the reason why has to do with deterrence. What this means is that the lawmakers that wrote the laws are given the court the discretion to apply a range of fines based on the specific facts of your case. So the more serious the fact situation is, for example, if you have prior convictions of driving under a suspended license, the higher the fines will be. Generally, if you've never been convicted of this charge before, you'll be facing a $1,000 fine. If this is a second conviction, then you'll be facing a minimum $2,000 fine. And those fines will increase with additional convictions. There are, however, exceptions. So for example, on a first conviction, sometimes the court will allow for not a $1,000 fine, but will go smaller at, let's say, a $500 fine. Or if there are aggravating circumstances surrounding the offense, such as if there was an accident, then the court may assess a higher fine than the minimum $1,000, even though this is a first-time conviction for you. 4, who makes the decision about the fine? Ultimately, the justice of the peace is the final decision maker about the fine. However, the prosecutor does have a lot of power and will suggest to the court what the fine should be based on his or her assessment of the facts. Generally, the justice of the peace will follow the direction of the prosecutor as long as the prosecutor is following the generally accepted guidelines for assessing penalties. 5, ask for time to pay. Regardless of the fine amount, you can ask the justice of the peace for time to pay. Generally, for larger fines above $1,000, it's quite common to get up to 12 months to pay your fine. However, the justices may, in some cases, only give you 6 months to pay. Now, regardless of whether you get 12 months to pay or 6 months to pay, the court system is open to giving you a payment plan, which means you may be able to pay off your fines over a few years. Now, we suggest you contact the court to discuss how to enter into a payment plan, as each court handles payment plans differently. Okay, as a next step, watch our video, what happens when you go to court for driving on a suspended license charge in Ontario. You can click on the video on this screen. And if you have any questions, message me to arrange a confidential and free meeting.